All right, the gentleman at the MDOC facility, can you tell me your name, please?
Jesse Hurst.
Okay. All right, Mr. Hurst, your attorney is not logged in yet. I'm going to put you back in the waiting room, and as soon as he's here, we'll bring you in.
All right.
Okay, good morning, Ms. Arnold. What cases are you covering today? Ms. Arnold, are you there?
She should be on shortly. Maybe she's on the phone, but she has Mr. Shears this morning, and I think Miss Burciaga.
Okay.
Here, my volume wasn't turned up. I couldn't hear.
Oh, all right. You have Ms. Burciaga and Mr. Shears?
I do, Judge.
All right, Mr. Lyons, Mr. Shears is here in the courtroom. Do you need to speak to him?
No, Your Honor. I think he and I have an understanding of today's hearing with regard to my motion.
Okay. Mr. Shears, you can come forward and sit at the table here closer to the television. Okay, this is file 25-22116-FH and 24-21752-FH, People versus Frederick Khalil Shears. We are here today for a pretrial conference in these cases, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the People.
May it please the court, George Lyons on behalf of Mr. Shears.
All right, and Mr. Lyons, where do we stand with Mr. Shears' case today?
Respectfully, I filed a motion to withdraw the counsel on both files, Your Honor. I believe the attorney-client relationship has degenerated to a point where it no longer serves the best interest of Mr. Shears for me to remain as his counsel.
Okay. Ms. Arnold, anything you want to say on that issue?
No, we have no position.
Mr. Shears, are you in agreement with that, or where do you stand with respect to Mr. Lyons' request to withdraw?
Well, I should have never hired a Michigan State guy, but definitely, if he don't want to represent me, there's not, if a guy don't want to go into a battle with me, it ain't no sense in wasting no time with him.
Okay. If that is the case, then I will grant Mr. Lyons' motion to withdraw. Sergio, could you grab the red folder from Francis? I forgot to bring that with me. We'll set this for another pretrial conference date and give you an opportunity, Mr. Shears, to find another attorney to represent you.
Thank you. And Your Honor,
I can go back to John Glazer.
Okay. I'll address that in just one second. Mr. Lyons, what is it that you were going to say?
Your Honor, I believe that I attached a proposed motion a proposed order to both motions.
Okay, so what I'm going to do is set this for a pretrial on May 28th. 8:15. And Mr. Shears, I can only appoint the public defender's office if you're unable to afford to hire your own attorney.
Well, that was the breakdown in,
Okay, so you are no longer able to afford to pay a private attorney, is that what?
yes, sir.
All right, so I will appoint the public defender's office then to represent you once more. I don't have control within the public defender's office who gets assigned to your case. That's you know, their purview. If Mr. Glazer represented you on these cases previously, I would assume they'll probably appoint him again.
Okay.
Okay, so again, your next date is May 28th at 8:15 a.m. and be on the lookout for some communication from the public defender's office.
Yes, sir. Thank you.
Thank you for your time.
I'm good.
If you're all set for today. Okay, Mr. Daly, Ms. Nicholas is here in person. You need to speak to her.
No, Your Honor.
Okay, Ms. Nicholas, can you come forward and sit at the table closer to the television, please? Okay, this is file 25-22170-FH, People of State of Michigan versus Brenda Lee Nicholas. We are here today for a pretrial conference in this case, and we are proceeding today partially by video conference and partially in person. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, may I have the people?
James Daly, on behalf of the defendant.
All right, and Mr. Daly, where do we stand with Ms. Nicholas's case today?
I think, Your Honor, there's been plea bargains offered, none have been accepted, and we're prepared to set this for trial at this time.
Okay, Ms. McClure, anything we need to address from the people's side?
No, the people would agree, and we did have, I believe, an exam in this case, and I don't know if we have the transcript.
Sorry, Ms. McClure, your audio is dropping out.
Judge, I don't have anything to add other than we have.
I'm still having an issue hearing you. I'm not sure if it's on your end or my end, because I've been having a little bit of an issue with other people as well.
I could try and call in.
That was better.
Okay, can you hear me now?
Yes.
Okay, so Judge, there was an exam held in the case. I'm not sure that a transcript was ordered yet.
Yeah, we're not getting good enough audio to continue this way. So yeah, if you want to try to call in, let's do that. Okay, I think we have,
Okay. Hello?
yeah, okay. I think we're all set.
Am I echoing?
No, we don't have any echo any longer.
Okay, I did for a second. So Judge, in this case, there was an exam held, and I don't believe a transcript's been ordered yet, as this is the first pretrial.
Okay. Mr. Daly, are you going to be requesting a transcript?
Yes, Your Honor.
I would be as well, and other than that, I don't have any objection to this being set for trial.
Okay, so. Okay, so, let's see, Francis, could you find us, well, I'm sorry, Ms. McClure, how many days do we need for a trial in this case?
Maybe 3. I don't know if Mr. Daly has any witnesses, though.
Mr. Daly, do you think 3 days is sufficient, or will you be calling witnesses that would extend us to another day?
No, 3 days we believe will be enough time to take care of this.
Okay, all right, so Francis, we'll need a 3-day jury trial date, and if we're ordering the transcript, we're going to be looking at probably end of August, first part of September.
Okay, sir.
We could do Wednesday, October 15th at 10:30, October 16th at 9 a.m., and October 17th at 9 a.m.
That works for the people.
Works for defense also, Your Honor.
Okay, let's set a final pretrial then, if we're starting on October 15th for October 8th at 8:15.
And could we have a pretrial maybe in August, just to check on the status and make sure we're getting that, we have the transcript, and give Mr. Daly one more chance to maybe discuss a plea?
Yes, how about August 13th at 8:15?
That works. August 13th, correct?
Correct.
Okay, yep, that works.
All right, the court will issue a scheduling order. Is there anything else we need to address with this case today?
No, Your Honor.
No, thank you.
Okay. So, Ms. Nicholas, your next date will be August 13th at 8:15 a.m. You're all set for today then? Call the jail for Mr. Tinder, please. Okay, the gentleman that's at the NCF hearings, can you tell me your name?
Joshua Matthews.
Okay. All right, Mr. Matthews, your attorney's not logged in yet. I'm going to put you back in the waiting room until he gets here.
Okay.
He's Mr. Matthews, your hearing actually is not scheduled until 11 a.m. So you can stay there, or you can let the officer that's with you know that you're not going to be here till 11 a.m.
Come back and look.
Mr. Fry, are you going to need to speak to Mr. Hurst?
If I could have a brief minute with him.
Okay. Mr. Hurst, I'm going to put you in a breakout session with Mr. Fry.
All right.
Okay, and I had someone join the meeting just a second ago. Your screen name, it appears to be the name of your phone. Can you just tell me your name, please?
Sabrina Burciaga.
Okay. Mr. Brandt, do you need to speak to Ms. Burciaga?
No, Your Honor.
Okay. So this is file 25-22115-FH. Cabrina, people of the state of Michigan versus Cabrina Burciaga. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Alfred Brandt for the defendant.
All right, and Mr. Brandt, where do we stand with Ms. Burciaga's case today?
Thank you, Your Honor. Your Honor, I did have a chance to talk to Madam Prosecutor yesterday. I'm still reviewing the affidavit for search warrant in this matter. This is a co-defendant case with Mr. Shears. I believe the court reset that for a pretrial May 28th at 8:15. I think it would be appropriate to have this case tag along with that and set it for a pretrial on the same date and time.
Okay, Ms. Arnold, anything we need to address from the people's side?
No, thank you, Judge.
All right, so we'll adjourn this for another pretrial on May 28th at 8:15 a.m.
Thank you, Your Honor.
Mr. Brandt, would you be willing to do a stipulation in order for that adjournment?
I can do that, Your Honor.
And you can sign my name to that.
Thank you, Allison.
Thanks.
Okay, so Ms. Burciaga, your next date will be May 28th at 8:15 a.m.
Okay, thank you.
Thank you. You can log out. All right, Ms. DeMont, do you need to speak to Mr. Tyndall?
No, Your Honor, we're ready.
Is file 25-22234-FH, People versus Terrence Jerome Tyndall. We are here today for an arraignment in this case, and we are proceeding today by video conference. We also have file 25-22149-FH, which is set for a pretrial conference as well as a pretrial on alleged contempt of court for violation of bond conditions. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure, May of the People.
Katerina Dumont for Mr. Tyndall.
All right, and Ms. Demont, does Mr. Tyndall wish to have the information read in the 25-22234 case?
No, Your Honor, we'd waive the reading and ask the court to enter into a plea of not guilty.
All right, we'll enter a not guilty plea for Mr. Tyndall in the 25 case and set that for a pretrial on with May 28th at 8:15. Are there any other issues we need to address with either of the cases today, Ms. Demont?
Your Honor, the newest file, Mr. Tyndall is able to be released from the Lenawee County Jail to inpatient treatment. We would be asking if the court would allow him to be released to inpatient treatment on the older file as well. I know the court was not ready to do so at the last pretrial we had. However, since then, Mr. Tyndall has been referred to drug court, and he has also been screened and evaluated with CMH. He's got his substance abuse assessment done, and he is approved to go to Home of New Vision. So considering the underlying issues in these cases are substance abuse, we would be asking if he could be released only to an inpatient treatment facility. And once we can do that, he can start on some rehabilitation services and hopefully also go into drug court. He also has no other prior criminal history other than substance abuse related offenses.
All right, Ms. McClure, any thing you want to say on that issue?
No, the people have no objection, but I did notice Mr. Coast just jumped in. I don't know, maybe he wants to weigh in.
Has Terrence been assessed? I mean, has he been approved to go to inpatient?
That is the information that I've received. I've been working with Miss White to get him in, and he advised that CMH has been over there, gave him the substance abuse assessment and has approved him.
Okay, if he's approved to go, I could work with Miss White.
Okay.
Okay. All right, so I'll modify the bond then in the older case, that's the 25-22149-FH case. So as to allow Mr. Tyndall to be released directly to a residential inpatient treatment facility.
Thank you.
Thank you, Judge.
All right, anything else we need to address with this case today?
No, Your Honor, I'll do the stip in order.
Okay, thank you for your time then, Mr. Tyndall. You can let the officer with you know that you're all set for today.
Okay.
Okay, Mr. Fry, are you ready to proceed with Mr. Hurst?
Yes, Your Honor.
All right, this is file 25-22182-FH People versus Jesse Hurst. We are here today for a pretrial conference, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure?
Phoebe McClure, May of the People.
Good morning, Your Honor. Brian Fry on behalf of Jesse Hurst.
Okay, and where do we stand with Mr. Hurst's case today?
Yes, Your Honor. Yesterday, Prosecutor McCready made a plea offer that Mr. Hurst is going to accept. The court should have received the amended information yesterday as well. My client would plead guilty to the added count 2, possession of methamphetamine. There's a sentencing agreement that any sentence would run concurrent with the MDOC sentence he is currently serving. And the prosecutor also agreed to dismiss count 1 and any supplements as victuals as part of the plea agreement. And I believe that's the entirety of the agreement, Your Honor.
Okay, Ms. McClure.
That's my understanding as well.
All right, I have not received, to my knowledge, a copy of the amended information yet.
Just want to make sure there's 2 in the file, so I want to make sure I send the correct one.
Okay,
And Judge, it doesn't look like either one is actually correct, so it might take me just a minute to.
okay.
I just forwarded the one that I had from Mr. McCready.
All right, while we're getting that sorted out, let me switch gears. Mr. Goldstein, are you ready to proceed with Mr. Simmons?
Yes, Your Honor.
Okay, this is file 25-22121-FH. People versus Isaiah D'Angelo Simmons. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayonetto?
Alex Bayonetto for the people.
David I. Goldstein appearing on behalf of the defendant.
And sir, you are Isaiah D'Angelo Simmons?
Yes, sir.
All right, Mr. Goldstein, where do we stand with Mr. Simmons' case today?
With regard to the pretrial, Your Honor, we're going to ask that the matter be set for trial. There is still possibility of resolution, but this will give us, your trial date is going to be, I suspect, some time out. And we can continue to discuss.
Okay. Mr. Bayonetto, how long do you believe we need for a trial?
Your Honor, I think we can get it wrapped up in 2. If the court wants to schedule it for 3 days, given the amount of officers that were present, and we're gonna have to bring in somebody from the Michigan State Police Lab. 3 would be the safest bet, but if the court wants to set it for 2, I think we might be able to get it wrapped up in that.
Okay. Mr. Goldstein, any input on that issue?
I would agree, Your Honor. I think 2 is probably correct, but 3 is safer. Mr. Bayonetto and I can talk about the necessity of the lab people, and that might help streamline things.
All right. I'm going to set it for 3 then. Ms. Clark, could you give us a 3-day jury trial date, please?
Tuesday, July 8th at 9 a.m., Wednesday, July 9th at 10:30, and Thursday, July 10th at 9.
Hang on, I don't believe I'm available then, but let me check. I actually have 2 jury trials already scheduled in Washington that week. I'm sorry, I'm looking in June. I'm sorry, you said July, didn't you?
Yeah,
Yeah, I've got a nasty CSC trial that week.
July 22nd at 9 a.m., July 23rd at 10:30, and July 24th at 9 a.m.
Trying to remember. Okay, I'm scheduled to leave at the end of that week, but that week should be okay. Hell no, you know what? I should have put it in my calendar and I didn't. I think I'm going to be gone that week.
Tuesday, August 5th at 9 a.m., Wednesday, August 6th at 10:30, and August 7th at 9.
No, I'm not going to be. Not going to be back until that Wednesday. Well, I'll be back Wednesday morning, but I won't be here Monday or Tuesday. I'm good the rest after August. After the 13th of August, I'm good the rest of the month.
Tuesday, August 26th at 9, Wednesday, August 27th at 10:30, and August 28th at 9.
Those would work.
That would work for me as well.
okay, so that was August 26th, 27th, and 28th. Let's do a final pretrial. So does August 13th work for a final pretrial, Mr. Goldstein? I lost track of it.
Yes, that would be okay, Your Honor.
Okay, so we'll go with August 13th at 8:15 for a final pretrial.
Judge, we also have that additional contempt of court.
Yeah, so I'm sorry, Mr. Costa, what was the appearance date we used on that?
Judge, you actually wanted it set for today for the contempt, the second contempt for him missing the 414 drug screen.
414.
That contempt should be in the file, Judge. It was also sent to Mr. Goldstein's office.
Didn't I give you a doctor's note for that?
You
Mr.
did.
Mr. Simmons, I don't want you to say anything about it right now, okay?
Okay.
I don't have that in the file at the moment.
Yeah, like I gave him a doctor's
Your Honor, I did receive something from your office that I'm assuming that Mr. Costa is referring to. And it said something to the effect that he had missed a test. He presented a doctor's note, and Mr. Costa indicated he believed that doctor's note was a forgery. And a forgery might not be the right word.
Well, I called it a fictitious note. I
Fictitious,
actually
thank you.
contacted the doctor's office, confirmed that he's not a patient there.
Yeah, I knew there was an F word. Anyway, I have not seen that document, Your Honor. So if we want to set it for a hearing, that's fine, but I'd like to be able to see that document before we respond.
Okay. All right, so Mr. Simmons, I will let you know that there is a motion affidavit and show cause, order to show cause that was signed yesterday. The allegation is that you failed to drug test for Mr. Coast on April 14th, 2025, and later supplied Mr. Coast with a fictitious medical excuse for April 14, 2025, trying to excuse yourself from that test. So that's what the allegation is. I will enter a not guilty plea for that and set it for a hearing at this point. Mr. Goldstein, do you think an hour is sufficient for that?
I would think maybe a half hour to an hour.
Okay. Ms. Clark, can you find us a 1 hour hearing date for a bond violation hearing?
Yes, Judge. 10 a.m. on May 15th.
May 15. Just hang on, my calendar just closed. May 15th at 10. Yeah, that would work.
I can do that as well, Your Honor.
May 15th at 10 a.m.
Your Honor, if the court is not going to consider remanding Mr. Simmons into custody at this time, given the multiple positive tests, and now we have this new allegation, would the court at least order a test today to be done?
All right, I'm not going to remand Mr. Simmons to custody today because he's entitled to a hearing and he's pled not guilty to it. At this point, it's just an allegation. I do think it is appropriate to require Mr. Simmons to test today. So Mr. Simmons is going to require that you come to the courthouse and see Mr. Coast and test today. I would also say that between now and the hearing on this matter, if we have further issues with respect to testing compliance, that the court would most likely issue a warrant as opposed to another summons for a show cause hearing.
Your Honor, I'm sorry, what time was that on the 15th?
That was 10 a.m. on the 15th.
All right, would you want us live or Zoom, Your Honor?
I think Zoom is probably sufficient for that one. Obviously, you are entitled to be here in person. Mr. Simmons is entitled to be here in person for that hearing, but if parties prefer to do Zoom, I'm okay with that.
Your Honor, again, I'm sure Mr. Coast will provide me with a copy of that document in the meantime.
David, I'll actually send you a copy this morning.
All right, thanks, Darren. Okay, thank you, Your Honor.
All right, we're all set in this case for today then. Mr. Evans, Mr. Murphy is handling his cases in Judge Anselm's court first. So as soon as he's available, we'll get to your case. Okay.
Thank you, Your Honor.
Okay. Oh, I'm sorry. Mr. Murphy is here.
Yep. Sorry, Your Honor.
That's okay. I've got blank screens. I can't keep track of them all. So, Mr. Evans, I'm sorry, Mr. Murphy, do you need to speak to Mr. Evans?
Your Honor, I spoke to him yesterday, so I don't need to. If you want to talk any further, I can, but if not, I think we're ready on the record.
Okay. So Mr. Evans, you want to come forward? You can sit at the table right here. So this is file 25-22157-FH, People versus Carlton Benjamin Evans. We are here today for a pretrial conference and proceeding today by partially by video conference and partially in person. And we're here today for a show cause hearing. Mr. Murphy, would you like to place your appearance on the record?
Yes, Your Honor. Thank you. Matthew Murphy, appearing on behalf of Mr. Evans.
And sir, you are Carlton Benjamin Evans?
Yes, Your Honor.
Mr. Evans, you are before the court today on an order to show cause related to an allegation that you violated your bond conditions. Have you received a copy of that motion in order to show cause?
Yes, Your Honor.
It alleges that you violated your bond conditions by testing positive for intoxicants on your remote breath test on March 28th, 2025. And again on April 12th, 2025. Do you understand that that's the allegation against you?
Yes, Your Honor.
do have the right to have a hearing on this matter, and you can't be found guilty unless the evidence at that hearing establishes that you're guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
Maximum possible penalty for a contempt of court for violating bond conditions is up to 93 days in jail or up to $7,500 in fines. Do you understand?
Yes, Your
Honor. Mr. Murphy, do you know how Mr. Evans would like to proceed on this matter?
Your Honor, from my understanding, Mr. Evans wanted to take responsibility and plead guilty to these violations, then asked that sentencing be set for the June 6th sentencing date already scheduled for his underlying charge.
All right, Mr. Evans, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
Do you understand you have a right to contest the contempt of court charge and have a trial on it?
Yes, Your Honor.
You can put your hand down if you want. And do you understand that throughout that trial, you'll be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, Your Honor.
You have the right to have all the witnesses against you appear at your trial. You or your lawyer can ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand that?
Yes, Your Honor.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, Your Honor.
On the other hand, you also understand that you have the right to testify if you want to testify.
Yes, Your Honor.
How do you want to plead to the charge that you violated your bond conditions by testing positive for alcohol?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, Your Honor.
Has anything been promised to you in order to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way in order to get you to plead guilty?
No, Your Honor.
If I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
So you've been on bond conditions in this case that require that you not consume any alcohol. Is that correct?
Yes, Your Honor.
And you've done remote breath tests to monitor that requirement. Is that correct?
Yes, Your Honor.
And on March 28th, 2025, did you test positive for blood alcohol at a level of 0.018 at 8:12 a.m.?
I believe it was the 28th, but yes, Your Honor.
Okay. And had you consumed some alcohol that day?
Not that day, no. It was the evening before.
You consumed alcohol the evening before and it was still showed up on the test the next day?
Yeah, it was like that night, like the middle of the night or something like that.
And then did you test positive again on April 12th, 2025?
Yes, Your Honor.
And had you consumed alcohol either that day or the night before?
Yes, Your Honor.
Okay. I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Evans has had full knowledge of his rights and he's had competent counsel. I will set this for sentencing on the same day as sentencing in the underlying matter, and that is June 6th at 8:15 a.m.
Thank you, Your Honor.
I would say, Mr. Evans, I take this issue seriously. The conviction here is for operating while intoxicated, third offense, and it gives me a lot of concern that you're continuing to consume alcohol, because when you do that, I don't know whether or not you're going to get behind the wheel of a car again, and I don't know whether or not you're going to cause a danger to yourself or someone else as a result of doing that. I will tell you that if there are any issues with your alcohol testing between now and date of sentencing, I am going to issue a warrant because that's what I feel I have to do in order to keep the community safe. So that's the situation right now. So you are all set for today then. And We'll see you back on June 6th for the sentencing.
Thank you.
Mr. Evans, I'll give you a call later this afternoon, okay? Thank you.
Thank you.
Thank you, Your Honor.
Okay, have we resolved the issue with the information from Mr. Hurst yet?
Yes, Your Honor. I believe Mr. Fry forwarded the correct amended information and plea form to both myself and the court. Oh, what's going on with that?
Okay, we are back on the record in file 25-22182-FH, People of the State of Michigan versus Jesse Hurst. And I do now have the amended information and a copy of the plea agreement. Mr. Hurst, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Jesse Hurst?
Yes, sir.
Mr. Hurst, you've heard the statements of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 on the amended information, possession of methamphetamine?
Yes, Your Honor.
Do you understand that the maximum penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court other than as it's been discussed on the record here this morning. Is that correct, Ms. McClure?
That is correct.
Mr. Fry?
Yes, that's correct, Your Honor.
Is that also your understanding, Mr. Hurst?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Hurst, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead then to the charge that on or about August 17, 2024 in Adrian Township, Lenawee County, Michigan, that you did commit the offense of possession of methamphetamine?
Guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Hurst to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Hurst, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've talked about it on the record here today?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
Mr. Fry, do you want to cover the factual basis?
Yes, I can do that, Your Honor. How you doing today, Jesse?
Good.
So on or about August 17th, 2024, were you in Adrian Township, County of Lenawee, State of Michigan?
Yes, sir.
And I think, were you in a motor vehicle at the time?
Yes, sir.
And did you have methamphetamine on your possession?
Yes, sir.
Okay, where did you have it?
It was in a wallet in my center console.
Okay. And did you know that that substance was methamphetamine?
Yes, sir.
Okay. I have nothing further.
People are satisfied.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Fry?
Yes, Your Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Hurst has had full knowledge of his rights and has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we talked about it on the record this morning. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 20th at 8:15 a.m. Mr. Hurst, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
All right, Your Honor.
Judge, should I do a Zoom writ or an in-person writ for that day?
Mr. Hurst, you have a right to be here in person for the sentencing hearing. If you don't want to come in person, you can waive that right and we can do it by Zoom. But I just need to know what you want to do, if you want to be here in person or waive your right and do it by Zoom. Oh, I'm sorry. I apologize. Having said that, we don't have fingerprint information, so it will need to be in person. So we'll have to bring you in person, have your fingerprints done here, and we'll do it in person.
That's fine, Your Honor.
Okay. All right, Mr. Moore, do you need anything further from Mr. Hurst?
No, Your Honor. We'll contact the prison.
Okay. Mr. Hurst, you are all set for today. Then you can let the officer with you know that you're done reporting.
All right, thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Fry. Okay. Mr. Murphy, Ms. Berger is here in the courtroom. Do you need to speak to her?
I don't think Ms. Berger is my client, Your Honor.
Oh, oh, I'm sorry. I got myself mixed up. Mr. Milaro is not logged in yet. I think he's in Judge Anselm's court. Okay, so Mr. Murphy, I have Mr. Owen at the jail. Do you need to speak to him?
I do, please, Your Honor.
Here's there, Evans. Okay, you can come forward and sit at the table here closer to the jury box. This is file 25-52438-PP. Zareth Evans versus Dustin Lee Evans. And we are here today for a hearing on an order to show cause for alleged violation of a personal protection order. And you are Zareth Evans, is that correct?
Yes,
All right, I'm looking at the file. It looks like an order to show cause was entered on April 18th, 2025. I don't have a proof of service showing that that was served on Dustin Evans. Was that done, do you know?
When I called in, they said that they had it. I'm not sure what happened there.
Okay, let me check the computer system. Sometimes it gets filed and the paper just doesn't make it to the file. So let me look. Okay, there is a proof of service that has been filed. It's in the computer system. Indicates that Mr. Evans was served on April 25th at 5:30 p.m. That was filed on, proof of service was filed on April 28th, 2025. So we do have proof of service on Mr. Evans. The record should reflect that Mr. Evans was ordered to appear before the court this morning at 8:15 a.m. for a hearing on an order to show cause for the alleged violation of the personal protection order. It is now 9:14 a.m. and Mr. Evans has not appeared either by logging into the Zoom session or by coming to the courthouse in person. So I am going to issue a bench warrant for his arrest, and I will set bond on that bench warrant in the amount of $1,000. And we will proceed with that violation once Mr. Evans is arrested on that warrant. Okay. All right, thank you. So that's all we can do for today. You're all set. Ms. Evans, can you hang on just a second? Okay. Just realize that this case is not assigned to me. It is assigned to Judge Anzalone. I believe it was put on my docket because I signed the order to show cause. So
Might be in the courtroom.
you might be down in the other courtroom. So what we'll do is send the file down there. If you want to just step down to the next courtroom, that's where it should have been. I'm going to disregard. I'm not going to issue the bench warrant, and we'll just let Judge Anzalone in. Sorry for the confusion.
That's okay.
Okay, Ms. Underwood, do you need to speak to Davey and Ryan?
No, I don't believe so, Your Honor.
Okay. Yeah. Can you call the jail if they have a second? I have jail Zoom 5 in my See Mr. Skip. Yes.
Great, thank you so much. Bye.
Yes.